Hello, my name is Andrew Marsh from TU Dublin, and I'm here today to introduce our sixth session in our Creating a Spinout series. Before today, we've talked a bit about creating your business model, how to get funding, but today I'm happy to introduce Shane Costelloe from Holmes, who's going to talk a bit about the roles and responsibilities of being a director, a little bit about company law.
Hi everyone, my name is Shane Costelloe. I'm Head of Employment at Holmes Solicitors. I've been invited by TU Dublin to speak to you about being a company director in Ireland. So we've been in business for 50 years. We are a full service law firm and are the sole legal provider for TU Dublin for legal services. We have 3 offices in Dublin, Limerick and Cork, and we have over 200 staff. And we provide a full suite of corporate and private services to our clients. We're 50 years in business, and we are very happy to always contribute to our clients in terms of a variety of issues and exercises, including presentations like this, but also community programs and volunteering. Today's agenda is split into 4 sections. First, we will look at the types of director in Ireland. Second, we will look at directors' duties. Third is when things go wrong, a key part of the presentation today. And fourth is some key takeaways for those persons in attendance. Now, it's important to set some context for the discussion and, in actual fact, set some background around where the term director comes from. When you're a company director in Ireland, it's very important that you're aware of what you're a director of. You are a director of a company incorporated under the Companies Act 2014. So where does the company come about? The company is incorporated under the Act and is used as a vehicle for persons in business. I'm sure you'll all be well aware of this. But why do people incorporate? Well, people incorporate because it provides separate legal personality for the company. It's separate from the owners of the company and those directors as well. It provides perpetual succession, meaning that the company can exist indefinitely. It provides a limited liability, which is probably the key aspect of why people incorporate. It separates the owners from that company entity. And that company entity can contract then freely without the worry of being judged bankrupt, as you would have in a case of a sole trader. Other aspects then that are important for a company, the fact that, for example, it can give a floating charge as security. So that's just one of the elements of why incorporation is so important when you're developing a business over its broad life cycle. The types of company then that persons often incorporate into under the Companies Acts, the most common you'll see is the private company limited by shares. Over 75% of the companies in Ireland are that type of entity. That is your limited company that you will all be very familiar with. The designated activity company then is a type of limited company, which, as it says in the tin, has a designated activity. So within its constitutional documents, it will say what the company's purpose is and also what the powers and rights of those shareholders and the persons who run the company are. It's often used in industries such as lending or in aircraft leasing, for example, or sometimes where there is an investor who sits far away, a different part of the world, and wants to limit the role that the company has or the role that the directors or the shareholders have in running that company. There are other types of company, of course. There is your PLC, which is your public limited company, but also your CLG, your company limited by guarantee, and that would be the entity chosen often by charitable groups. It's a company that doesn't avail of profit, and it's also a company that would have trustees rather than members. Now, when it comes to directors, it's important to point out that for a limited company, there's only the requirement to have 1 director, but for the DAC, there's 2. And the 1 director in the limited company will always require a separate person to act as company secretary. There must be at least 1 director resident in EEC. Often a problem in recent times due to Brexit. So we have clients who have company directors who were resident in the UK, But then after Brexit, it was determined that those persons were no longer relevant or possible to be directors under the Companies Act. Now, with directors, there's often, the issue of board meetings, the frequency and form, but also what their role is. All of those aspects would be generally referenced in the constitution of the company, something I'm sure you're familiar with if you've incorporated a company. But the constitution is, in fact, its grounding document. It is the contract that exists between the shareholders and the company itself as a separate legal person. You will often have a shareholders agreement that sits in tandem with the constitution and will set out the roles and responsibilities of the director. It's important to say, of course, that the directors in Ireland have a statutory obligation, and we'll talk about this a bit more later. So the types of company law director then. Often you'll have your company director who's registered by way of the CRO, the A1 form is submitted, and as I said, at least one or maybe two directors are appointed, depending on the type of company. But there are other types of director that can exist, and this is something to be very conscious of when you are when you're a promoter or founder of a company. So, for example, shadow directors are where somebody sits behind the scenes and is telling the directors or instructing them how to carry on the business. Those persons will be deemed directors under the Companies Acts. Second of all, you have de facto directors. So someone who's not been formally appointed, but acts as a director in all guises. Many external parties will see them as a director of the company, even though they haven't been appointed. It's possible that that person could also be held to be a director of the company. Alternate directors then are often provided for in the Constitution or the shareholders' agreement, where a director who possibly isn't available to go to a directors' meeting, a board meeting, would appoint an alternate to sit in their stead. Now, it's not always the case that alternates will just be allowed to attend a meeting without some consent or written approval of the other shareholders or board directors, but that's often catered for in the Constitution, as I said. Managing directors then is a concept that's actually not spoken about in the Companies Act. It's, I suppose, an appointee between the directors for someone who's going to run the company, often referred to as a CEO as well. Many small companies don't actually require a managing director, but look, out of good governance, it is often seen that somebody needs to take the lead. So managing directors, whereas the title may be interchangeable, are often used, I suppose, in a variety of companies. When it comes then to executive and non-executive directors, again, two phrases that aren't necessarily spoken about in the Companies Acts. They don't have any legal standing. But what an executive director does is it's someone who works in the business effectively. The non-exec then, on the other hand, is a person who might be appointed to the board to provide some external advice. You'll see as the company grows in its life cycle that non-exec directors appear more and more on the board. They might be certain persons with specific expertise around accountancy or sales and marketing. But they'll often be maybe appointed by an external stakeholder. So if you have gone out to the market and received some money from a third-party investor, they may say, I would like a seat on the board. And that person is often a non-executive director. So they don't work in the business necessarily, but they have a lot of oversight and sit on the board. The second section of today's talk is about directors' duties. Now, this is the key. This is the meat in the sandwich, I suppose. Any director in Ireland has an obligation to adhere to their duties, their roles and their responsibilities. The Companies Act 2014 sets that out. But there's also a different source of duties in Ireland, and that's common law. So common law is the position that's developed over time based on court decisions. And in Ireland, you have the common law position and the statutory position. This applies across many aspects of the legal field. But when it comes down to directors' duties, the common law position has been around for a long time. But obviously with the Companies Act 2014, the statutory position is a relatively recent idea. It's worth mentioning at this stage that there are various other forms of legislation that apply to company law in Ireland. Companies Act 2014 is the broad spectrum and captures most of the old acts that were repealed back in 2015 when the act was adopted. But there are other aspects of law like EU regulations and directives that must be adhered to. Now, just draw your attention on the slide to the second piece. It's a bulleted point there. And actually, this is just an important point to note. So when a company is applying for incorporation for the first time in a CRO, and you have your A1 form and you're filling it out, you've put in your company name, the address, the shareholders, you're asked for who the directors are, and the directors, of course, will have to sign that. It's important to see that where the directors are signing, just below that, there is a phrase, I acknowledge that as a director, I have legal duties and obligations imposed by the Companies Act, other statutes, and common law. So you are acknowledging that these duties exist. Now, every director in Ireland would have to sign that type of form. So in effect, you're giving your consent to adhere to those aspects of the legislation and the common law. So if we focus on the common law duties for a second, there are three to mention in particular. So directors must exercise their powers in good faith and in the interests of the company as a whole. Number two, directors are not allowed to make an undisclosed profit from their position as directors and must account for any profit which they secretly derive from their position as a director. Number three, directors are obliged to carry out their functions with due care, skill, and diligence. Now, I suppose they're quite broad in the drafting of those particular common law duties, and the courts will apply them in a variety of circumstances. Two quotes from the ODC are really important here, and these came up in the case law. It was in 2012. It's a very, very important thing for any director to remember. Just because you're a director of a small company doesn't mean that you are carved out from any obligations that you have. The Companies Act and all their statutes apply exactly the same to all directors, whether you're in a PLC, a family business, or even an indigenous or multinational company. So the second quote is actually more important. I'd like to jump to that. So it would be contrary to the whole notion of proper corporate regulation that passive directors would be exonerated from a liability or relieved from disqualification or restriction on the basis of passive nature of their role. So what's that saying? Really what it's saying is that there is no way that a director can just say, look, I wasn't involved in the day-to-day running of this business. I didn't attend board meetings. I didn't know what was going on. Somebody else took responsibility for that. That's never going to be good enough. If there is an issue with a company and it's going to be penalised under the Companies Act, and we'll talk about that in a second, all directors could be liable. It's not good enough just to simply say, I washed my hands with that company, I had no idea what was going on there. So if you are appointed as a director, it's very, very important that you take as active in a role as you can, and also stay in touch with your other directors, seek information from the company, make sure that you're complying with your obligations, because it may happen at some stage if some other director has brought the company into disrepute that you could be caught up in that mess. Statutory duties then, I suppose they were codified for the first time in the Companies Act 2014. Before that it was all a common law position. The statutory duties then, of which there are 6, seem very obvious. Some are a bit more innocuous than others, but at the same time, this is where the penalisation, the criminal offences, and the fines arise based on the fact that they are statutory duties. So the first one is a duty to act in good faith in what the director considers to be the company's interests. So this is a subjective duty. So don't forget that the director themselves has the option to employ this duty as they wish. So it's a case of the director using their skill and knowledge to make sure that they act in good faith. The second statutory duty is a duty to act honestly and responsibly in relation to the conduct of the affairs of the company. Now, this is acting honestly in the best interest of the company, not the best interest of the director. You will have seen that in the common law position or the common law duty around acting honestly and in good faith, that there is no option here for a director to benefit personally from their position as a director. A director could be found personally liable both in criminal and in civil law if there is issues that arise against the statutory duty. Thirdly then, in terms of statutory duties, is a duty to act in accordance with the company's constitution. We spoke about this a bit earlier. The company's constitution is the document that lays down in black and white how the company will act vis-a-vis itself, vis-a-vis its shareholders, and sometimes vis-a-vis with outside stakeholders. The company confers powers on its directors through its constitution, and it's very important that the constitution is upheld at all times. The director has that duty. Fourth then is a duty not to use the company's property, information, or opportunities for his or her own or others' use. This is probably the most common duty that's breached. So, for example, a director who works with one particular business but maybe has personal interests of their own, and often directors could be involved in sectors which are closely aligned with one another. So, they have a business in one particular area, but have then been asked to come on the board of not a competitor, but someone who's maybe in the same supply chain, different levels, but could add a bit of value to the board. It's the fact that they have information at their fingertips within that supply chain then, which they could use to their own benefit, that becomes very attractive for a director. It is very important for a director to maintain their statutory duty that they don't do anything with the information they come in connection with in relation to this confidential role that they take on a board. The next duty then is the duty not to agree to restrict the director's power to exercise an independent judgment unless approved by the members or permitted by the company's constitution. This one's a bit of a mouthful and a bit tricky, but in actual fact what it means is that you shouldn't fetter the judgment of another director. If you are a director of a company, you should have your own thoughts on what happens with that company. And we'll see a bit later from one of the examples that I'm going to show you what happens when a director has I suppose an unnerving amount of control over the rest of the board. The last statutory duty then is a duty to exercise care, skill and diligence having regard to the interests of the members of the company. The members, of course, are the shareholders. So the director's duty is actually owed only to the company, but this is where the statutory duty brings in the shareholders and what the directors owe to the shareholders. So when it says exercise care, skill and diligence, it may be the case that a director is asked to chair or sit on a remuneration committee or an audit committee, and they may have some specific skills in that area if they're an accountant by trade or maybe have some experience in doing books and records. So the director would have a responsibility to act appropriately in that regard. Now, it is important to remember that you can, of course, bring in professional advisors to assist in that regard, and actually that would be a manner to show that you've done something that has exercise care, skill and diligence, where you say, actually, I don't have the skill here to operate in this kind of field. I will need professional advisors to come in and help us with the decision making here. That's absolutely fine. And actually, not bringing in professional advisors where you don't have the skill set there on the board could be seen as a negligent act in itself, something to be very conscious of. Third section then is probably a little more interesting than a lot of legalese that I was just speaking about there, is when things go wrong. There are potential liabilities, of course, for directors. These are set out in the Companies Acts themselves, but at common law, as in a civil case, there could be other damages that are applied by a judge if a director is found personally liable for having behaved poorly or had issues of misjudgment. So you'll see there from the slide that there's actually 3 categories of official fine that are set out under the Companies Act. Now, I will say, in my experience, I haven't seen many of these applied, so I wouldn't be too concerned that you would be the person who is dragged in front of the courts and subjected to such a conviction, but they exist, right? So we should really focus in on them. So where we say that the duties of director are owed to the company and where the director breaches those duties, how does it actually get to the stage where there would be a court case? Well, if a shareholder says, this company has plummeted in value based on the fact that corporate governance is really lacking in this company and the directors have done nothing to implement any kind of care, skill or diligence, then that's where you end up with a problem. Shareholders say that their value has been eroded and that they're going to sue the directors based on the fact that they've done something wrong or ineffectively or fraudulently. Category 1 is the worst case scenario, that is a conviction and indictment can result in a term of imprisonment of up to 10 years and also €500,000 in fines. Category 2 then is conviction and indictment up to imprisonment for 5 years and €50,000 fine. And Category 3 then is only for a summary offence, which attracts a 6-month imprisonment and a €5,000 fine. As I said, it doesn't come up too often. Most likely potential liability for a director is in fact to be restricted or disqualified. Now you see that comes up most often in an insolvency situation where the ODC get involved. And we flick back, if you look at your slides quickly, if you go back to the first comment from that slide earlier, it talks about ODC quotes. That came up in the context of an insolvency situation. So it's not good enough for a director to say again, oh, I didn't know what was going on here. I had no idea the company was in such trouble. And all of a sudden the company has a liquidator appointed and someone is saying, a creditor is saying, I'm owed €5 million, and those directors did not do their job. How does that arrive at my door? It arrives at your door because you're a director. You don't have to have had an active role in it, and you could end up with a potential liability, personal or even criminal. So I just want to touch on a couple of examples which should assist you in seeing what can go wrong. And the reality here is that obviously this is quite an extreme example. We'll all pretty be familiar with the case of Enron, a company in the US. So it's the story, and just read from the slide for a second, it's the story of a misdirected strategy leading to ethics and governance failures. So when we talk about corporate governance is a very key aspect of the director's role. Directors should be heavily involved in corporate governance in terms of the preparation of proper meetings, having proper structures in place, appointing audit committees, remuneration committees, making filings with the CRO, having regular meetings with other stakeholders from the company, including investors, shareholders, and that entire piece that we call corporate governance is probably one of the key elements that an external investor or stakeholder will look at before they put their own money into the company. As part of a due diligence in a transaction, it's often one of the key items is, well, how do you structure yourself? What kind of meetings have you had? Have you kept board meetings for the last 5 years, the minutes from board meetings for the last 5 years? Have you done all your filings? Please provide your corporate history. What have you done in terms of training, in terms of corporate governance? So this is where it's come to the point now where it's absolutely critical. But at the time of Enron, which was 2001, when that company filed for bankruptcy, corporate governance was something that we probably didn't hear about too much. So the story of Enron is where a company arose after a merger of two companies focused on deregulation of the natural gas industry in the US. They then diversified into different areas of construction, industry, and energy, and was seen as had a market cap value of 60 billion by the mid 2000s, sorry. And Fortune magazine announced it as the company of the year in 2000. Now, the board of Enron was stacked full of multiple individuals from various backgrounds. There was CEOs of other companies, there was 3 very well-known academics, there was former politicians, and there was the wife of a senator. So it had some very high-profile individuals. Now, they brought to the table different skill sets, and that was the reason that they were there. They were there to provide, I suppose, a collaborative effort to strategize around where Enron should go. What they didn't do was investigate what management were up to. So management had, for a long time, been carrying out fraudulent accounting practices where debt that had been arisen due to failed transactions was buried on the balance sheet or not accounted for at all. They'd also tried to fraudulently interfere in the energy supply in California. So they had caused an energy shortage where even the electricity was switched off at some points, and they would benefit from that. So this company was involved in some awful activities altogether. The board said afterwards, when the government provided a report into the Enron scandal, they said the board had no clue that this was going on. Whether that's true or not, we don't know. But I suppose it goes to the fact that the board can't just say, we didn't know what was going on. The board has to take steps to investigate what the company are doing, what management are up to, and to adhere to law, company law generally, but also civil law. Enron in 2001 filed for bankruptcy. 4,000 employees were laid off, and the Justice Department opened a criminal investigation. Not saying that that would happen to any early stage company in Ireland, but the learning is that actually you need to put in place some really good, strong corporate governance structures at the start. So if you can build a culture around corporate governance from day one, this will be of huge benefit to you when you're going out to raise money, or dealing with Enterprise Ireland, or at any time of a sale, or even for general practice, just generally when you're trying to manage management going forward. The way to do that is to have a strong constitution, have some strong guidance around when board meetings are held, have some strong guidance about who we appoint and why they are joining the board, and then have regular situations where directors also participate in training. You might train your staff all the time, or have encouragements for them to take educational courses, but many companies often overlook the responsibilities of the board and training their board. The second example I want to talk about is the Mirror Group and Robert Maxwell. Now, that name hasn't been in the press for a long time, but his father actually of Ghislaine Maxwell, who was in the press a lot recently in some recent documentaries, which I'm sure many of us saw. But Robert Maxwell was the head of the Maxwell Corporation. He was a media mogul. He was a well-known playboy who was known in many cities around the world. But it turns out that he was also a fraudster. So this really is a story of how unchecked dominance can bring down an empire. So Mr. Maxwell was a very domineering character. He sat on his board and he bullied other directors. He told them what would happen. It was his way or the highway. The learning here is in fact about when you have directors who are what you might call in the US a patsy, who are on the board simply to make up the numbers. It's often the case that the numbers of directors will be applied by investors. So they might say, look, we'd like a board of no less than 5, no more than 9. And we will take 3 or 4 board seats on that and appoint some independent persons. Now, if you've got some very strong characters on that board, you want those independent persons, first of all, not to be bullied into situations where they are voting in a certain way. But second of all, very importantly, that they have their own voice because they have a statutory obligation, as we've seen. So Mr. Maxwell obviously didn't adhere to this concept or I suppose, put any value on his other directors' roles or voices. And I suppose what it ended up it was actually that it allowed him to carry out a fraud of a huge scale. The Mirror Group eventually collapsed, and Mr. Maxwell died in tragic circumstances, but in disgrace. So we see that it's actually, a really key aspect of the board is that you have independents who have their own voice, who are able to speak their own mind and maintain their own position on the boards. So the appointment of persons who may just be there to make up the numbers is not going to be good for your governance. It's an absolute no-no really when it comes to outside investors. They will want to know and do their own due diligence on board members from head to toe. So the final section then of the talk is around key takeaways for any proposed or existing company director in Ireland. This is just really, I suppose, to capture some of the issues that we spoke about, but also chat about some of the realities and practicalities which follow on from our examples here. So, as I said, get governance right from the start. Now, it's really key that you would suggest somebody who would be responsible for the governance while on the board. Now, the company secretary can often do that, but the company secretary, don't forget, doesn't sit actually on the board. They would be entitled to attend board meetings, but you would need someone who has the ability to control the board of directors. This is where the chairman comes in. In a small company, you might say, why do we need a chairman for the board? It doesn't really seem suitable. We don't even have a managing director. We don't have a CEO. We like to think of things as being more collaborative. The problem you have is that where there is maybe an equal number of directors on a board, and a deadlock might arise, you might need a casting vote or just someone to put some shape on meetings and have the ability to control their other directors. So appointing someone with responsibility for governance who sits on the board is absolutely a bit of good advice. This allows to get governance right from the start, put a governance plan in place so that there might be training to happen after a certain number of months. And of course then it's a good way to demonstrate to outside parties that you've taken your governance responsibility seriously, but also that you do business in a serious manner. So when someone comes to invest externally, they will keenly examine your governance approach. That's point number 2. I work a lot in corporate sphere as well when we do a lot of due diligence on transactions, so in the buying and selling of businesses. A due diligence questionnaire will come in if we're acting on the sell side or in investee side, where an investor is coming to give you money. And they'll say, I'd like to ask you all these questions about your company. Now, it touches on topics like employees, property you might own, assets, commercial contracts. But as I said earlier, the very first question they always ask, tell me about your business, tell me about the company structure, and tell me about your governance. Who are your directors? What is their history? Where do they own what other investments do they have? What kind of conflicts of interest do they have? It's an absolute key aspect of if you are in that life cycle where you want to grow, you want to take investment, you want to be attractive to an outside investor, it is absolutely key that you have your governance approach in good shape. So number 3 then is to, I suppose, as a key takeaway is to recap on something we mentioned earlier, which is regardless of the company size, the obligations on a director are applied. And I'll just bring you across to that comment again that's on the right-hand side of that slide. It's the ODC statement. So it would be contrary to the whole notion of proper corporate regulation that passive directors would be exonerated from liability. Again, if you're sitting on a board and you are a director, take an active role in the company. Be interested. You don't necessarily have to have the skill set to be involved in things like accountancy or corporate governance, but at least asking the question and saying, can you please explain this to me in a bit more detail, will really be enough for you to demonstrate that you've taken the steps to try and protect the company or act in the best interests of the company. Asking the question and asking the question to be noted in the minutes at board meetings will be enough for you to be, I suppose, exonerated from that liability aspect. If something is going on behind the scenes and someone lies to you, then it's very easy to show that once you've asked the question and it's noted in the minutes. Now, that applies regardless of size. I know we're speaking to some people here who might be directors of large companies, medium-sized companies, but mostly, early stage companies. Now, with an early stage company, the board could be 1 or 2 people. It's actually a good opportunity to get your plan in place for what the board might look like later. So regardless of company size, get those obligations down in paper, get your plan for how you might grow the board over time, and consider and talk to your colleagues about where investors have focused in with them in terms of board appointments. So what kind of questions did they ask? Who did they appoint? Why did they want that person on the board? What kind of job does that person do? How involved are they in the day-to-day running of my business? It's great to share information like that because a lot of institutional investors like the NDRC or WDC or Enterprise Ireland will take very similar approaches, which they might have a passive role at the start, but they may want someone to sit on the board later on. It's very important to get those learnings from people so that you can put a plan in place that looks very attractive to an outside investor. The 4th key takeaway is in relation to D&O insurance. So this is directors and officers insurance. It's insurance that is provided for the actions of the directors and officers so that they are protected in themselves and that they can take decisions that, I suppose, won't restrict them from acting in the best interest of the company. So you can imagine if a director is constantly worried about every decision I take is under scrutiny. That is the case because of the Companies Act. But as I said, the reality is that the penalties don't often come up until you're in an insolvency situation. So where you're taking decisions at an early stage, you can be brave, you can be bold, but in actual fact, if you have the directors and officers insurance in place, this can provide a backstop to the potential for personal liability. So, if you've asked a friend or an advisor to step on the board and they say, look, I don't really want to do that, it's going to be a personal obligation for me, it's got potential for me to be restricted or to me to have a personal judgment against me in terms of a penalty. If you've got the D&O insurance, that should kick in to protect you against negligent acts that could arise and bring up a damages claim in court. So look, often early stage companies will say it's not an expense we necessarily want to have in early doors, but it's something that it's worth looking into very early on. If you don't have a very large board, it mightn't be a requirement. But again, it's about putting that plan in place to arrange what your board might look like in the future, and just even mentioning the fact that you've considered D&O insurance is another opportunity for you to demonstrate to an outside person that you are taking governance and the directorships very seriously. The last point then is just training. So as I said earlier, directors can avail of training in places like the Irish Management Institute or in a variety of locations actually, including academic institutions like I'm in at the moment. But the reality is that the training of directors is often overlooked. Training of staff happens all the time, but training of directors, depending on the size of your board, depending on the complexities of the issues involved, would be something that first of all attracts directors to join your board, because don't forget, if you're in the stage of maybe 1 or 2 years into your life cycle and you're looking to grow, you're looking to maybe raise a serious funding round, you want to either attract a director who will act on your behalf, on the company's behalf, but also to demonstrate that the board is very serious about its role and what it's going to do to an outside party. If you can attract someone who's an industry-specific expert, that looks fantastic. But it's actually training up the persons who sit on the board with them, who, for example, might be responsible for accountancy or audit remuneration, training them up into aspects like that so that they can provide those services without having to bring an expert in. So thanks very much for your time today. It was a pleasure to talk to you. It was a pleasure to be invited by TU Dublin to speak to you guys. I hope it was interesting. The takeaways, I know, were kind of, I suppose, tried to be a bit more practical, but we have to remember that the statutory obligations exist. Many of you either are a company director or considering becoming a company director or are setting out on your company's life cycle and may be required to be a director. So hopefully an hour of information like this will stand to you, but it's important to remember that upskilling all the time is a key part of your journey, and we'd be happy to help you along that way if we can at all. So thanks to the guys here in TU Dublin, and thank you.
Thanks, Shane, for that very informative talk on being a director. So as Shane said, we'll now open it up to any questions.